Good afternoon, everyone. This is the World Arbitration Update, and my name is José Antonio Rivas. I am a partner at Strategy LLP, and I am also co-chair and co-founder of the World Arbitration Update, which was first launched in 2021. And because in many continents this forum was well received, we are doing the 2022 version now. First of all, I would like to thank our sponsors, and then I would like to thank the panelists, which will be introduced by my former colleague Álvaro Galindo, and I have the task of first of all emphasizing that this panel, I must say that this panel is a panel that has had an incredible degree of depth, not only because of its content, but also because of the organization that we've seen by the panelists, including Pascal Akoui and Julia Levashova, and all the other panelists. But this panel has been thought of from the beginning of the year, and I can only say thank you to all of them. I won't introduce them, just not to embarrass them twice, only once by Álvaro. And let me share a couple of notes about our moderator. Our moderator is Álvaro Galindo. Álvaro is a former colleague of mine at ICSID when we were both legal counsel there many years ago, at the beginning of this century, which sounds like a long time ago, but it's not that long. And Álvaro is an international counsel advising on complex international arbitration matters, particularly those involving Latin American jurisdictions. Now he is the dean of the law school at the Universidad de las Américas in Ecuador, and he's also a partner at Carmignani Perez law firm. His practice focuses on disputes between sovereign states and state-owned entities and private companies. He is recognized by the Legal 500 Latin America since 2012, and was noted in this publication as outstandingly intelligent and for his incomparable capacity for coordinating, planning, strategic assessment, and for his diplomatic approach. I mean, I could go on and on and on, but I think that it is fair to stop here and not to embarrass Álvaro. You know, he's really at the top of the game, and I'm really glad that he's both pursuing academic endeavors still and acting in practical matters as counsel still. Now, I would like to emphasize that this panel is really a panel that is based on the research and drafting of a book since the end of the 2021 World Arbitration Update, we considered of importance to share with the whole public a book review and a book related panel. And lo and behold, as we were planning the whole coordination of the WOW 2022, by sheer luck, and also thanks to Munia, who is our presenter here, we were introduced to Pascal, who shared that the book entitled "Balancing the Protection of Foreign Investors and States' Responses in the Post-Pandemic World" was about to be published by Cluer. So this is and now it is published by Cluer, and we have only panelists that have been contributors and drafters and authors and co-authors of that book. So we have the two chief editors of the book, Pascal and Julia, and we have a truly exceptional panel to talk about some parts of the book on issues that are both academic, but mostly practical issues related to force majeure, as well as necessity and other topics. Of course, we cannot cover the whole book, but by covering these topics, you will have a taste of those issues. We will be throughout the presentations of the CVs showing you the book itself. There it is, so that you can see it. And Pascal and Julia will be in charge of sharing with you any specifics about where to get it or buy it, etc. So now with that, I would like to give the floor to Álvaro and to all the other panelists. Álvaro, it's great to have you here. Please have the floor.
Thank you very much, José Antonio. It's a pleasure to be in WOW. It's very motivating to start this discussion with a terrific panel for today. The idea of the panel will be to have around 80 minutes now. We will have approximately 5 to 7 minutes by each of our presenters, and then we will move forward at the end with some final remarks. And finally, we will have different rooms in order to have some networking between the audience, the participants, and the panel members. Now, I would like to give the floor to our first panelist. You must be seeing her in the screen. She is Munia Elharti Alonso. She will make a first presentation of the subject matter that we will be addressing today. Munia is a senior consultant at boutique law firm Strategy LLP in Washington, D.C., specialized in international arbitration. She was previously in a law firm in Mexico City, a very relevant law firm, and a delegate to the European Union delegation to the United Nations in New York. She's an attorney admitted to the New York Bar. She holds an LLM from Georgetown Law Center, where I had the pleasure to have her as one of my students in my class. And she's currently pursuing her PhD at Universidad de Madrid on international renewable energy disputes, where she lectures on the subject. So Munia, the floor is yours for 5 to 7 minutes.
I will aim at 5 to 7 minutes. Thank you, Álvaro. Thank you, José Antonio Rivas and Ian Lurt for the kind invitation, and to my co-panelists as well for being here, as well as the audience. So my presentation will address the key trends and use of emergency provisions, including force majeure, relevant during the pandemic and other political turmoil or war situations. I'm using the comprehensive, encompassing term emergency provisions, or you can call it emergency clauses, as found, for instance, in the CMS versus Argentina case that has that broadly encompassing concept of the clauses. And my presentation will give a practical 360 view. It doesn't make fine doctrinal distinctions that I leave to my other co-panelists. I will outline in a schematic way that the use of emergency provisions is first reflected at a systemic level in the very legal framework of contracts and treaties as risk allocation devices, but they are also crystallized at a more micro level in the dispute itself, and I will only highlight the most salient claims with notable foreign selection consequences within the dispute as to the request of arbitration, stay of proceedings, quantum, and finally, on post-award proceedings with enforcement. So to my first systemic point, emergency clauses are most known as defenses, of course, but there are also, and prior to that, found as risk allocation devices within the legal framework in contracts and in treaties. So this is notably decided in the Strabag versus Libya exit award of June 2020, where the tribunal begins with an important observation that force majeure provisions exist to allocate risks resulting from exceptional, often large-scale events that cannot be anticipated. So therefore, they are within contracts or general law. And it adds that the tribunal task is therefore to identify and give effect to the risk allocation agreed by the parties in each contract. So this is an exit case based on a contract. This is at para 791. This is also the view that was found in Gurius versus Libya, the ICC case. And the tribunal extends this view of risk allocation to investment agreements that encapsulate the risk allocation. And I want to highlight that within this treaty framework, there is something particular that is relevant within the investor treaty context, or the investor-state trinity, to quote Patrick Pearsall, where the state is both a party, a protector of investment, and also the lawmaker. So in consequence of this, the risk allocation view in the treaty context is somewhat one-sided, as it seems that by including it in the treaty, the state in its treaty drafter hat thus assumed the risk. So this is the case in Gurius versus Libya, where when you read the tribunal's decision, it says like by virtue of Article 4 of the Syria Italy BIT, the contracted parties assume the risk of war, conflict, emergency, etc., which might occur and cause losses, etc. To ensure against the occurrence of such harm, the contracting parties undertook to offer adequate compensation. And then it says it is not open to respondent to invoke as force majeure the very risk against which it has undertaken to offer an indemnity. As to the protector of investment hat that I mentioned within the trinity of party, lawmaker, and protector of investment, this is also reflected in the context of Article 25 ILC on necessity. It can be argued that if the act in question safeguards an essential interest of the state, or if it doesn't seriously impair an essential interest of the state towards which the obligation exists, necessity can come into play. This was argued in CMS versus Argentina and analyzed by the tribunal in those terms. And interestingly, the tribunal says that if the treaty was made to protect investors, it must be assumed that this is an important interest of the state parties as well. Whether it is an essential interest is difficult to say, however. Finally, I want to touch upon within treaties to an interesting clause that is not found in all treaties, which are the war losses clauses. So we often talk about force majeure and other types of clauses, but there are specific clauses such as war losses clauses or armed conflict clauses that would be interesting to see within the Russian-Ukrainian context, for instance. And they can be found in certain treaties, such as Article 4 of the 2002 Syria-Italy BIT that I just mentioned. Notably, the US took this clause out in its 1984 model BIT and brought it back in 1994. It is still present in the current 2012 version. And some states attempted to make use of those specific clauses in an exculpatory way. Argentina as well in the CMS and total cases, but to the contrary, tribunals decided that they are actually an additional guarantee for investors to not be treated in a discriminatory way. More recently, Syria and Libya also attempted to make use of those specific clauses in the Gurs versus Syria and Gurs versus Libya cases. Finally, on my
one
section,
more minute, Monia.
okay, well, I will just do one section and my presentation systemic only. And final point on the interaction of the two frameworks of the two regimes, contract and treaty. When interpreting a treaty clause, the arbitral tribunal will likely refer to the treaty rather than the contract, as was seen in Ample versus Egypt. And it is likely that we will see force majeure or even more specific clauses as war losses clauses that I just mentioned popping up in recent cases. And I now give the floor back to Álvaro.
Thank you very much, Munia. That was perfect on timing and perfect on your remarks, and give us a perfect setting now to enter into more particular topics to be addressed. I will just mention a couple of things before I give the floor to Pascal in relation to the fundamental change of circumstances. As you all know, Article 62 of the Vienna Convention on the Law of Treaties is the relevant article in relation to the particular topic of the fundamental change of circumstances. And this article, and I would like to mention just the relevant part of this article in paragraph 1, a fundamental change of circumstances which has occurred with regard to those existing at the time of the conclusion of a treaty and which was not foreseen by the parties may not be invoked as a ground for terminating or withdrawing from the treaty unless, and then we have two points, the existence of those circumstances constituted an essential basis of the consent of the parties to be bound by the treaty, and B, the effect of the change is radically to transform the extent of obligations still to be performed under the treaty. So commentaries on this particular article have mentioned that this is a consequence of the pacta sunt servanda principle, which is basically that contracts are made in order to be performed, in order to be respected. And when the drafters to Article 62 of the Vienna Convention of the Law of Treaties drafted this particular paragraph, they had in their minds the principle of pacta sunt servanda. So they drafted this in a very, very particular and restricted way in order to not allow to have a floodgate of exceptions in the future for states to withdraw from their obligations and try to invoke the change of circumstances in order to escape those obligations that are relevant under different treaties. I think this is very important in terms of the environment that we're living today. We are coming out of more than 2 years of the pandemic, and we have heard, we have read many news outlets and specialized publications that have mentioned of the invocation of the fundamental change of circumstances by states in order to escape from obligations that are relevant under different investment treaties. So under this particular framework, it is important to see and to be very attentive of how the tribunals are going to address this particular issue. I think based on the facts that we have seen in the last 2 years, is going to be very difficult that at the end, this article is going to be a escape valve for states to withdraw from their obligations under investment treaties. And that was the intention originally from the drafters. So I think that at the end, we will see a consistent, hopefully, consistent approach by international tribunals, and will have to follow ad hoc cases based on the facts in order to decide whether to leave this article as it is or to open the floodgates for different claims that could be brought against sovereign states. Now, with that particular framework, I'm going to give the floor now to the one who is responsible with Julia of this panel because of the importance and the relevance of the book that is being launched today. Pascal Acouil-Lorfing is an associate member of Credimi. She is a research, which is a research center on international markets and investment law, affiliated to the University of Burgundy in France. She's a lecturer at ASCP Business School in Paris, and an adjunct affiliate at Tucarola Center, the Center for the Advancement of the Rule of Law in the Americas of Georgetown University Law Center. She holds a PhD in international law from the University of Paris II, Assas. Her first book on the recognition of the international contract was published by Brillant in 2011. She is a member of several working groups, including the Working Group on International Contracts, and she is a regular contributor to international law reviews with several publications on international contracts and investment contracts. Pascal, you have 5 to 7 minutes for your remarks. And I would like to address first a question to you. And the first question that I would like to pose to you is in relation to the force majeure topic. What are the important aspects to be aware of when invoking the force majeure exception, and why so?
Thank you, Alvaro. Thank you for letting this panel happen and advertising the book that Julia and I have co-edited, and it's published today by Clover. I mentioned that my intervention will last less than 7 minutes, so I will not go in depth and invite the auditors to read the chapters in the book. So thank you for your question, Alvaro. What are the important aspects? The pandemic and all the crises that happened since the pandemic, the economic, the sanctions, the climate change, etc., shows that any event that has a certain characteristic and may make the performance of the contract impossible, and this is what qualifies the situation of force majeure. And the force majeure may be invoked by a state under 3 possible grounds: and customary international law, and under national law or soft law, and under the clause that may be inserted in the contract. Under customary international law, very quickly, it's the Article 23 of the responsibility of states for international wrongful acts, adopted by the International Law Commission in 2001, that states for some characteristic of the force majeure, and where the force majeure does not work is when the conduct of the state when the state is responsible by its conduct of that situation, and when the states assume the risk of that situation. There are plenty of case law. I won't go into details. It's on the book. Under national law and under soft law, what is important to note is that under some national law, the concept, it's called by different terms, but it leads to the same concept. It could be called the force majeure, objective impossibility, or supervening impossibility, but it's force majeure. And this concept is not of mandatory character. It means that the party may design a clause according to their wish or to their needs, if we may say, by restricting or expanding the notion, characteristic, or impact. We have also this specificity in the national law is that there is no obligation to notify the other party, which we can't understand today. And there is also a variety of the nuance in this impossibility. Some national law states for the temporary impossibility that suspend the contract, others the partiality of impossibility, the partial impossibility, and all records for the performance that becomes impossible, and that's it, and it terminates the contract. Under soft law, we have the specificity that the defaulted party should, it's an obligation, should notify the other, and also its double requirement should also ensure that the notification has been received. Otherwise, the force majeure does not work. You know, we don't have force majeure because the other party has not been notified. Now, under the clause, we saw the party that can restrict or strengthen the criteria that would qualify a situation of force majeure. We have seen in one clause the exclusion of the unpredictability test by the party, and that has been accepted by the tribunal. The parties also may add unusual requirements in this type of clause, such as the event does not makes it's impossible for the parties to perform the obligation under reasonable economic conditions. That usually, this criteria is usually related to the hardship and not to force majeure. We have seen also added unusual requirements, such as the event makes it impossible for the party to perform their obligation, and I said it, and the occurrence of that event does not release the party from its responsibility to perform its obligation. So there is no such force majeure in legal provision. And we also seen a force majeure situation that does not terminate the contract, but suspend it, and inviting the parties to try to reach an agreement. And if they fail to agree, to go to arbitration. So there is no termination as a principle, but as a possible to renegotiate and then to refer to arbitration in case of disagreement. So, and I would like to recall the ICC model clause version, the new version, that states for a list of events that qualifying force majeure, and this list presume that the event, if it exists, fulfill the condition of the beyond reasonable control of the defaulted party, or that the party cannot reasonably foresee this event, which makes it going automatically to the qualification of the event if such event is listed in the list. This is all what I have, and this is what makes it important to insert a contractual clause on force majeure, to be aware of what you put into the clause, specifying very clearly what are the criteria, what are the impacts, plural, suspension in case of partial impediment, or what to do, terminate or not the contract, because the party are able to draft, to design the force majeure as they want. And I recall the parties to insert, given the circumstances that we face since the pandemic, it's an important clause to be inserted in the contract to avoid the application of customary international law that is very restrictive, and they might be not in line with the parties' will, and to avoid the specificities of the application of national law that may be not in line also with the wish of the parties.
Thank you, Pascal. Let's move to another topic that is, of course, related to the one you just mentioned, which is the essential security interests. And for 1 minute, which is the time that we have left, I would like you to mention why the provision on essential security interests is considered important to include in international investment agreements. And this is linked to something that I would like you to address in that minute, which is whether you have seen any developments in recently concluded investment agreements regarding this particular provision on national security interests?
Yes, I don't know if I can in 60 seconds. It never happened, but I will try.
Let's give it 75.
Thank you, Álvaro. Why it is important? What is an essential security interest? It's a treaty provision. It's a treaty provision that allow the state to take an essential security interest measure and that may impact the foreign investor's rights without compensating that investor. It's not in line with the international investment agreement that usually are aimed at protecting the foreign investors. Here we have an exception to this protection by the essential security interest. It is inserted in the newly BITs or international investment agreements since 2010, let's say. It is surprisingly not in the 2019 Dutch model BIT, which is really unexplained. It may have multiple formulations by drafted in general terms or with a list showing the connection between the need to take essential security interest and yes, and what are the recent developments very quickly? We witnessed since 2019 a clarification on the meaning of the provision in the text, in the footnote, in the annex, clarification on the limits of such regulatory measures. It should not be arbitrary, not be discriminatory. The clarification on the exclusion of such related claim from the scope of the dispute settlement mechanism. It's very important. And recalling sometimes in the provision that the measure takes does not constitute a breach of the provision of this agreement. These two exclusions are very, very important. And we will witness how the arbitral tribunal will deal with this and how these specification will be interpreted. We see also a development in the way of drafting the provision. It's a different title for the same exception. We have a merging of the provision on exceptions in the same provision, like general exception and the essential security exception, and a specific provision, and this is really very late, a specific provision as an exception on specific areas such environment, labor affairs, and health are the matter of example, and also example on environmental protection as a general exception, which in the climate change environment today will have a huge scope. And we hope, and I hope that the arbitral tribunal may give this kind of provision, I mean, the scope it needed, and we hope that it will be in that direction, and not to take the position of Eco-Ordo, who just said that even in the existence of the provision on essential security interest and the way it is drafted, it leads to the application of the other protection provision of the investors and lead to the compensation, which is not at all the concept that this exceptions has in the center. Thank you very much. I hope I responded to all your questions in such a limited time.
You did, Pascal. Thank you very much. And you mentioned at the end such a relevant case law on the Eco-Ordo versus Colombia case. And I invite our audience to read the dissenting opinion in that case by Professor Philip Sands, which I think is after all, when dissenting opinions are worth something. So thank you very much for that, Pascal. Now we will go to Julia Levashova. She will give us some remarks related to the EFT provision. And before that, I would like to mention that Doctora Levashova is an assistant professor at Nyenrode University and the associate research fellow at Utrecht University in the Netherlands. Julia is also the director of the dispute prevention program at the Asia Pacific FDI network. Her specialization is in international investment arbitration, commercial arbitration, CSR, and due diligence. Julia served as a legal consultant to the Dutch government and international organizations as UNICE, UNCTAD, on the matters of ISDS and CSR. So welcome, Julia, and I would like to pose a first question to you, which is as follows: how the a fair and equitable treatment standard has evolved in recent ISDS cases or jurisprudence, as some call it, regarding the balance between the state right to regulate and the protection of foreign investors.
Thank you very much, Álvaro, and I would like to, first of all, thank you, José Antonio, for organizing this panel, and of course, Pascal, the co-editor of the book, and all the panelists who kindly contributed to our common project. So not to take much time on the introduction, I will try to dig into the issue on fair and equitable treatment standard. Just briefly mentioning that one of the biggest fears during the pandemic was that there will be a huge wave of cases based on the COVID-related measures on the basis of the fair and equitable treatment standard. However, as we have seen so far, this has not happened. We have seen several cases. We will see what the result of those, a little bit more of the commercial arbitration cases. However, the issue of balancing of the right to regulate and the right of investors under the FAT standard has never been more relevant than now, considering other type of cases which are emerging. And I'm talking about the climate change related cases and the cases which have strong environmental protection standards involved. So I will start just by saying that in terms of the state right to regulate and the investor protection under the FAT, the common misconception is that tribunals in interpreting the standard do not sufficiently acknowledge the right to regulate. Because based on my extensive research and the jurisprudence on the FAT standard, specifically rendered in the past 7 years, tribunals have been explicit in recognizing the state right to regulate, asserting the investor's right under the standard. However, there are some other problematic issues I will address further. Just firstly, to summarize the findings of my research, the recognition of the right to regulate and the assessment of the FAT clause is comprised of several elements. Firstly, independently on how a FAT clause is formulated, tribunals tend to acknowledge their common consensus that states have a right to regulate under customary international law. Secondly, tribunals recognize also states' ability to modify their laws as a part of the right to regulate, and this right has been emphasized, I mean, to modify the legislation as a result of multiple claims in which investors challenge regulatory amendments made by host states. And thirdly, the state legitimate objective in serving the public interest is among factors that is assessed as a part of an overall balancing exercise. And this is something which have not been in the earlier decisions. The common critique regarding FAT standard primarily concerns the broad interpretation of the legitimate expectations vis-a-vis the state right to regulate. And just to summarize, because all the details and all the cases are mentioned in my chapter, in the recent cases, tribunals have underscored that the assessment of legitimate expectations implies, and this is important, I think, in inherent balancing of state right to regulate in the right of investor. So this is the part of the legitimate expectation standard itself. The way how tribunals perform the balancing exercise varies. Usually tribunals do not follow any particular methodology in weighing the expectation of an investor and the state regulatory conduct, but instead they have developed a checklist for the assessment of the legitimate expectation, and a starting point is the assessment of type of commitments relied by the investor. Either those are specific representation or based on the stability of the regulatory framework. And then additional factors that play a role, such as which could be playing a role in the assessment, is the severity of economic impact, the extent of change, the procedure followed by a state, the public interest involved, external circumstances, and sometimes the due diligence performed by an investor. The problem, however, is a lack of clarity regarding the hierarchy and allocation of weight among those factors in the final determination regarding the breach of legitimate expectations. More importantly, a state legitimate objective in serving the public interest is only one among other intermediary factors in tribunal assessment. And sometimes it might be problematic, specifically in cases that involve a strong public interest, as we have seen and already mentioned by Álvaro or against Colombia case. So I think I will wrap up on this point.
Thank you very much, Julia. Let's move on to a second question, and you will have 2 minutes to address that particular question. In the assessment of the FET standard, one of the contested issues in investment law is the scope of permitted regulatory changes under the expectations of stability, and this is recognized by numerous arbitral tribunals. This issue is particularly relevant in the framework of claims concerning public health or protection of the environment, as you already mentioned in your first remarks. How do tribunals tend to assess the notion of stability in claims based on frustration of the legitimate expectations arising of changes to a regulatory framework motivated by the involved public interest? So we're talking here about the police powers and the regulatory powers of the state. Please, Julia.
The scope of permitted regulatory changes is, as you mentioned in your question, is indeed subject to ambiguity. And this partially explains why the cases with similar factual background might have completely different outcomes. And then well-known example of such variations are the energy decisions against Spain, prompted by the renewable energy reform by Spain. And even though there are some differences in some cases, several decisions that concern the same state reforms undertaken in the same period of time often contain trusting conclusion on the scope of permitted regulatory changes. As I mentioned before, tribunals generally agree that the regulatory framework cannot be frozen for the lifetime of the investment. So it's one of the elements of the state's right to regulate. The extent of the permitted changes is, however, subject to varying interpretation by tribunals. The prevalent number of tribunals underline that the state has an obligation to ensure a stable and economic legal regime, and that FET protects only against drastic or fundamental changes. And this type of definition does not really say much regarding the scope of permitted regulatory changes, because drastic or fundamental changes can be interpreted in many different ways, and this happens in numerous decisions. Well, I would like to just point maybe to one case, which I found quite helpful. In the recent decision, Renergia against Spain, this is award of 2022 under the Energy Charter Treaty, the tribunal offered a more clear framework for assessing stability and in the context of legitimate expectations of an investor. And in this case, tribunal spoke of the notion of relative stability that the state should afford to the investor. And more importantly, the tribunal specified the criteria, but play a role in assessing the legitimate expectations based on stability. And those factors are magnitude of change and abruptness of change, meaning that the more fundamental and more sudden the change is, the more likelihood of the violation on the part of the state. Other criterion underlined by this tribunal is the economic impact on the investor. And furthermore, the tribunal also referred to the external circumstances, explaining that in case when circumstances beyond the control of the host state, as opposed to mere change of the internal policy, the more likely such legislative changes are remain within the acceptable margin of change. It's not the subject to protection. And other mentioned criteria was public interest involved and the legislative history, which should be taken into account by the investor. To this list, I would add another important criterion, which I already mentioned for the assessing of the notion of stability, namely the extent of investors' due diligence and the absence of which in some cases led to the determination that the legitimate expectations cannot rise to the level of protection. For example, in several cases, I will just mention a few, Stadtwerke München against Spain, Antares against Czech Republic, Alejandro Gaspar against Costa Rica. In all of those cases, tribunals found that due diligence performed by the investor was superficial or even non-existent in some of those cases. And that was the key factor in finding that the investor cannot rely on the protection of legitimate expectation arising out of stability of a regulatory framework. So those are just my several observations, and I hope I'm in time with my presentation.
Thank you. Thank you very much, Julia. And actually, we have a question from you from José Antonio. So if you have the capacity to answer it in 30 seconds, I will read it for you very quickly. Does your research show trends of jurisprudence constant in the sense that the state has the right to regulate and there is no obligation to maintain certain investment regulatory environment as if there was a stabilization clause? Or is there a greater tendency of the type of jurisprudence that points out that if FET implies maintaining the same regulations in existence when the investment was made, e.g. as provided by the TECMED Tribunal? And this is interesting. When I first read the TECMED Tribunal against Mexico, I thought the tribunal had in mind Switzerland and not Mexico as the respondent party in that particular case. But anyway, that's just a comment. So Julia, please.
Well, as I mentioned already, I definitely see certain trends. And when I'm just looking back at the research which I did some years ago for my PhD on the FET standard, and at this moment there was a clear signal that right to regulate was something which was a rather intermediary factor behind the scenes and not very constantly addressed in the decisions. And currently what can be observed is that there's a clear framework in how the right to regulate has changed in this context, specifically in the FET cases. And the most important change, I think, are the specific criteria that are applied by the tribunals in the decisions. and which I mentioned already, is the undisputed nature of the state right to regulate, because it was not always the case, which is stemmed from the notion of sovereignty, and the factor of that the state can change the regulatory framework on the several conditions, and finally the public interest, which in the earlier years has been rarely mentioned or has been an insignificant factor in assessment of FET standard or legitimate expectations for this matter, and at this moment has been explicitly referred to and analyzed in a different way. However, there's an obvious understanding, and you can say the trend of growing importance of notion of the public interest.
Thank you, Julia. I think this has been perfect to close with your intervention. Thank you very much. Now I would like to give the floor to Crina Baltag. This is, as some will call it, the cherry on the cake of this panel. And Crina will give some final remarks after she has heard our panelists and she has reviewed the book. So just to mention that Crina Baltag, she is an associate professor, docente in international arbitration at the Stockholm University and qualified attorney at law since 2004, with an extensive practice in international commercial and investment arbitration, international dispute resolution, private and public international law. So, Crina, the floor is yours for 7 minutes.
Thank you very much, Álvaro, and I would like to take this opportunity to thank José Antonio Rivas for the wonderful week that they put together for us, and I invite everybody to take a look at the other sessions and attend them. Very useful for us practitioners and academics. And also, of course, for today, this was extremely, I would say, welcome discussion. And Pascal and Julia were very generous to invite me to write the final chapter of this excellent book. I invite everybody to read it, and it was an honor because, of course, I regard them, highly regard them, and it was a pleasure to collaborate with them and with the other authors of the chapters. But I think the discussion today has summarized that. Of course, we are hopefully out of the COVID-19 pandemic, which has brought, I would say, uncertainty and challenges for all of us, but mostly for the businesses and for the states equally, but also opportunities for innovation, collaboration, and why not for reassessing priorities. And we could hear today, Munia has mentioned that we are still in emergency times. We are now facing geopolitical situations with, we don't know exactly what consequences, but it is a still evolving situation and environment at the moment. And the discussion today is timely because, of course, not only the situation is evolving, but also the stakeholders involved in investment disputes, in investments in particular, are reassessing their positions when it comes to the legal framework in which investments are made. And related to this, international investment agreements have been criticized, and we know that, for protecting foreign investments at all costs. After all, they started as being investments for the promotion and protection of investments. without allowing host states the necessary space to implement policy measures in the public interest. And Munia has mentioned the holy trinity of treaties, where, well, why not? As public international law, states are treaty makers. At the same time, they need to protect their investors and their investments. And at the same time, in disputes, they are the parties, usually respondents in these disputes. Now, I think the entire framework that we see today, as I was saying, it's an evolving one, also because the system of investment law and dispute resolution, ISDS, is currently under reform, and treaties are updated. We see new model treaties being released. We see new treaties being renegotiated, some of them without the dispute resolution clause. And of course, the way in which states are allowed to regulate in the public interest probably takes a different shape. Now, going back to what Julia was saying, that the COVID-19 pandemic has not produced significant cases or significant disputes up to this moment, I think it's something that we need to learn from, because the response of the states adopted during the COVID times was probably peculiar. And I say this because there was a collaboration between the society and the businesses, and the fact that the investment agencies that we usually see them at the national level promoting and protecting investments, they actually took a role in informing investments, current investors in the state about the measures implemented by the state. And this, my conclusion on this is based on a OECD paper which was released in June 2020 on investment promotion agencies in time of COVID-19. So there was a survey conducted on how these agencies have reacted in informing the businesses. And at the same time, states had their interest in allowing investors or implementing measures which allowed investors and businesses in general to cope with the COVID-19 situation. So I do believe that we do have lessons to learn in how states and investors have collaborated during these times of COVID-19. Now, when it comes to investors and states, obviously, and especially when it goes to the disputes, to investment disputes, we can say that they sit on opposite positions. And of course, the question is what tools each of them has to make a claim arising out of this emergency situations, and what tools states have to defend themselves against claims brought up by investors in response to these measures implemented by states. Julia has mentioned and discussed aptly the fair and equitable treatment. And I would just point out, of course, we see an evolution of the fair and equitable treatment in the way that it's regulated, with legitimate expectations of investors being one element or one factor that can be taken into consideration by the tribunals, and not one expression of the fair and equitable treatment. And of course, the lack of let's say, clarity in how tribunals would consider the various elements of the checklist that Julia was mentioning for the fair and equitable treatment, with, of course, the examples from the solar cases. I would say that taking the lessons from COVID-19, probably when it comes to fair and equitable treatment, investors could argue at the most the way in which the measures have been implemented in the way that were transparent, the investors were duly informed. But as I was saying, I believe that states, or most of them, appreciated the need to be transparent on this. Of course, we have expropriation, MFN and national treatment clauses. And of course, one should not forget that there is the requirement not to discriminate also in the fair and equitable treatment, as Julia was mentioning. When it comes to states, and I think this is where most of our discussion today focused. Of course, Álvaro mentioned Article 42 of the Vienna Convention on the Law of Treaties with fundamental changes of circumstances. And I do agree that this is kind of unexplored territory, and we're going to see some developments happening, in particular when it comes to the geopolitical situation at the moment. The right to regulate, of course, in public interest, as a customary international law right recognized as such by tribunals. Now, if we look at the treaties and the way they are updated, one example I just want to bring at the table, which is the Energy Charter Treaty. Pascal was mentioning the exceptions provisions in the treaties. Energy Charter Treaty was one of such treaty which has still the exception provision. The new version of the treaty will also include the right to regulate as a standalone provision in the treaty. And it is expected that this provision will exclude expressly the possibility or for investors to claim when the state has adopted regulatory measures, in particular when it comes to lessons learned from the solar cases, the changes in tariffs and other elements of the regulations. Force majeure, distress, necessity. Pascal was mentioning, of course, pay attention to the national laws. This is very important when it comes to understand this defenses, in particular the force majeure, and also always a wise advice to provide this contractually where possible. A comment on this, as some of you might know, the UN has released the latest report on the responsibility of states for internationally wrongful acts this year in 2022, with updated cases concerning the provisions of the ILC report. And it is very interesting that in chapter 5, circumstances precluding wrongfulness, on article 23, 24, 25, the case that is mentioned is the Sutter versus Madagascar case, which is an investment case which ticks all the three boxes: force majeure, distress, and necessity, rejected by the arbitral tribunal. So for those interested, also listening to us today, make sure that you check the latest UN report released in 2022 on the draft. I think my conclusions are here, but I wanted to go back to the book, and I was mentioning it is a very useful tool. Besides being authored and written by excellent practitioners in the field, it is a useful book irrespective of the emergency situations we're going to face, and one hopes not many in the future. But of course, it addresses the three very useful perspectives one would like to see in such a book. The state responses to the pandemic, as I was saying, investor protection during pandemic and emergency situations, and the tools available to investors. And what I found very useful reading the book and writing the last chapter, the case studies from around the world. So not only health crisis, but emergency situations in general. And unfortunately, this is something that both investors and states have to be aware of and address them appropriately. Thank you very much, Álvaro.
Thank you, Karina. This has been perfect to close our panel discussion. I am very happy that I was invited to moderate the panel. I have learned a lot from your remarks, and it has been an update in terms of recent case law, the particular topic that you raised, Karina, on the report of the ILC articles So this is very important and very rich for the discussion that we have had today. So now I think we will have some indications by our hosts. José Antonio is here with us on how are we going to be organized for the networking of the panel with the audience.
Thank you very much, Álvaro, and thank you. I am giving thanks in the order that I see you in my screen. Pascal, Karina, Julia, and Munia, thank you very much for your in-depth remarks and for really stepping up to the challenge, not only of the topic, but also of a very strict moderator. Thank you, Álvaro, for that. I think that we got an in-depth discussion with really questions that I believe are not that easy to answer, and I'm really interested to look into your research, Julia. My sense, my sense to the question that I posed is more that perhaps there's more of a jurisprudence constante in the sense that the right to regulate includes the possibility not to understand an FET means that the regulatory environment when the investment was made needs to be frozen for the end of time. That is sort of my sense from reading decisions against the Czech Republic or that went in favor of the Czech Republic and Hungary and others, and some of the cases in Spain, etc. And that's sort of my sense from reading jurisprudence. But I'm curious as to whether my sense is supported by statistical evidence, etc. But I'll be very, very eager to read some of your research and many here as well. And Karina, I would like to say that the topic of the ILC and developments on the state on state responsibility and that has been and how that has been sort of understood and developed by investor jurisprudence is a very interesting topic, so much that is one of our topics for our sister events in at the end of 2022 this year, the Washington Arbitration week. So we might knock on your door again to discuss these topics. In any event, Pascal, masterful. Thank you for putting it together and for clarifying force majeure and giving some I wouldn't say case or factual advice, but reminding people and drafters that it is better to include things in the contract as opposed to leaving it to the chance of customary international law, etc. So and Munia, thank you very much for putting a baseline which is quite good. Now, in terms of next steps, I would invite you all to the networking. I think that we should have enough attendees for perhaps 3 or 4, perhaps three-way breakout rooms. There's no agenda in the breakout rooms. It is a safe space. It's not recorded. You can ask questions. You can talk about the weather or whatever you wish. And welcome to the breakout rooms. And thank you very much to what I must say was an excellent panel. I wish everyone wrote a book before each panel, but it's not the case necessarily. Thank you.